Thanks for joining us today for Jennifer Schaus and Associates in our Webinar Wednesday program. We're coming to you live from Washington, D.C. Our webinars are every Wednesday and are provided complimentary. They are recorded and can be downloaded from our website and YouTube channel, which now holds over 300 of our government contracting webinars. In the interest of time, we do not take questions, so if you have questions for our speaker, we will have her information on the last slide of the presentation today. A special thanks to our educational sponsor, the National Veteran Small Business Coalition, for making these webinars possible. The NVSBC is the largest nonprofit trade association for veterans. Please visit their website for more information. And now a little bit about us. We work with U.S. federal government contractors, including product, service, and software firms. Our services range from market analysis reports to contract vehicles and compliance. More information is on our website. We also have opportunities for your organization to advertise in our newsletter. We now reach over 18,600 subscribers, and this includes both contractors and government. Contact us for pricing information with the email shown on your screen. And now to introduce our speaker, Maria Panichelli. Welcome, Maria. We're glad to have you here with us today, and I'll turn the floor over to you.
Thank you so much, and thanks to everyone out there who's joining us today. My name is Maria Panichelli. I am the chair of the Government Contracts Group and a partner at the law firm of Obermeyer, Redmond, Maxwell, and Hipple. I focus my practice exclusively on federal government contracting, and that practice includes several different areas of work, helping clients through every stage of the procurement process, from bid protests, both asserting and defending, REAs and claims, performance counseling, small business procurement, False Claims Act work, teaming, joint venturing, mentor protege programs, and a lot of what we do also relates to subcontracting, and specifically the drafting and negotiation of subcontracts and the resolution of subprime disputes. And that's what we're going to be talking about today. So next slide, please. Excuse me. So again, we're going to be talking about successful subcontracting on federal government contracts. Next slide. So the overarching themes here, and what you're going to hear me kind of refer back to throughout the presentation today, is this idea of cooperation and communication. If you want to avoid disputes between the prime and the sub, whether you're the prime or the sub, if you want to avoid disputes with the other party, the best idea is from the very beginning to understand that you're going to have to work together, and this is about cooperation and communication. That's true of any partnership or any relationship, but it's especially true when you're dealing with the federal government, just because federal government contracts can be more complicated and there can be serious consequences if the prime and the sub are not on the same page. And there are also, reasons that you want to be a united front and be cooperating to make sure that you're compliant with everything. And we're going to talk about that as we go forward today. So you want to make sure that you demonstrate a willingness to work. In other words, nobody wants to be pulling their partner. So you want to make sure that both parties seem like they are willing to work and willing to work together in terms of compromise and whatnot. You want to make sure that there's honesty and trust between the partners. And transparency. Everybody wants to be telling, the other party exactly what's going on. No hiding the ball, no lying, no trying to point fingers, or kind of smudge the truth to avoid blame. Open communication. Everything should be shared, and then of course there should be empathy and understanding. First of all, just because that's the nice thing to do, but let's be honest. Even in a business relationship, kumbaya is nice, but from a business standpoint as well, empathy and understanding will help you understand what you can put in your subcontract, what's willing or what's likely to actually work out. And it can also help you understand, as we're going to talk about as we go forward today, what you can and what you probably can't negotiate in a federal subcontract. Next slide, please. So the first concept you need to be aware of when you're talking about federal government contracts is the idea of flow-down clauses, sometimes called pass-down clauses, but usually called flow-down clauses. Flow-down clauses are FAR clauses. That's the Federal Acquisition Regulation, which is kind of the Bible of government contracting, as many of you know. Flow-down clauses are FAR clauses included in a contractor's prime contract with the government. So in other words, the prime or the general contractor's contract with the VA or the Corps of Engineers, etc. And there are clauses that the prime contractor is required to flow down to their subcontractors. That's technically what a flow down clause is. That being said, it's kind of come to mean, or people use the term to mean, not only those ones that the prime contractor is required to flow down and put in their subcontract and hold their subcontractor responsible for, but maybe the ones that, even though it's not mandatory, they choose to flow down, they choose to account for. And the term can also encompass other clauses that are added to the subcontract that's meant to kind of shift risk or share risk between the prime contractor and the subcontractor. So again, know that technically speaking, flow down clauses are the clauses that the prime contractor takes from the contract and passes on to their contractors, most likely the mandatory flow down clauses. But it's also kind of come to mean in common parlance a wider variety of clauses, kind of anything that's meant to take the ideas or concepts of the prime contract and flow them down so that the obligations that the sub has mirrors the obligations that the prime has. Next slide, please. Now, the unique world of federal government contracting has a big part to play in the prime-sub relationship. Obviously, in any relationship, and in any relationship where there's an owner, the owner is going to have some part to play or some influence or impact on the relationship or the terms of the relationship between the prime and the sub, or the general and the sub. In some other areas, obviously, people call it the general contractor. Federal government contractor, we usually call it the prime. But because federal government contracting is a little bit unique, it puts additional stresses or kind of adds additional nuances to what's going on between the prime and the sub and why they will or won't negotiate certain terms. Federal government contracts differ in many respects from commercial contracts or sometimes even from state or local government contracts. They are governed by, as I said before, the FAR, which is the Federal Acquisition Regulation. Certain agencies also have supplemental regs, such as the DFARS for the Department of Defense and the Department of Defense kind of sub-agencies. And the VAR, for example, for the Department of Veterans Affairs. And also, depending on whether or not you're dealing with a small business set-aside or something where small business procurement regulations come into play, they might also be governed by small business regulations, the SBA or the VA's small business regulations. That's not an exhaustive list. There are obviously other laws like CICA, the Competition and Contracting Act, the Administrative Procedures Act, the APA. But, you know, in terms of the ones that come up the most often, you're talking about the FAR and the agency supplemental regs. And if you're dealing with a small business contract, the agency supplemental regs. And if you're dealing with a small business contract, the small business regs is too. Because of the way that the disputes are set up, the way that both the prime and the sub have to kind of structure their claims if things go wrong on the project, they're subject to a completely different set of dispute resolution procedures. And you go to different forums. In terms of dispute resolution procedures, they're laid out in the FAR and in the Contract Disputes Act. And when you've got a dispute between the prime and the owner, you're going to the Court of Federal Claims or the Board of Contract Appeals. You're not going to your local state court, and you're not going to the district court in a different state. They're subject matter specific courts. And we're going to talk a little bit later in the presentation how you might still, on a prime sub issue, end up in another court. But again, this is all kind of interrelated. So you have to be aware of the relationship and the rules and kind of the things binding the prime contractor and how they can deal with issues between them and the owner to understand how that kind of trickles down or impacts the subs. Finally, if you're dealing with federal government contracting, you've got different theories of recovery and different legal bases for claims. It's not breach of contract the way it is in a lot of other places. It's equitable adjustments and whatnot, and then seeing how that affects a potential breach between the sub and the prime. Next slide, please. For all those reasons, the flow down concept might be a little bit different in the federal workspace, and it might be a little bit more important. And what do I mean by that? So anytime you've got a subcontract, as I said, the relationship with the owner, between the prime and the owner, or the general and the owner, is going to somewhat impact the way that the prime, if he's smart or she's smart, sets up the relationship with the sub. But in the federal space, the prime is held to such standards under the FAR, and there's such a heavily regulated set of behavior that they need to engage in, that it becomes a lot more important, at least from the prime's point of view, to make sure that they're covering their bases and avoiding risk. So government strict regulations. They're not going to negotiate their contracts the same way you might be able to negotiate a commercial contract or a local contract. Government doesn't bend. The FAR clauses that apply are going to apply. Prime contractor doesn't really have a lot of wiggle room in terms of negotiating their contract. They put in their proposal or they bid, and if they get the award, they get the award. They're not there haggling over clauses and crossing things out. So because of that, prime contractors can't really be that flexible, and therefore may be reluctant to negotiate with subs about clauses. Now, the exception to that is if they can kind of, remember going back to the first slide, that empathy and understanding. If you are a sub and you can kind of say, look, I understand what the prime is trying to do. They need to protect themselves given the strict regulations that they are being held to by the federal government. But I know that, I can let them protect themselves, but also look out for myself. So I might not be able to negotiate clauses A, B, and C because the prime is going to think those are absolutely necessary to account for the risk that they have vis-a-vis the government. But clauses X, Y, and Z, those aren't necessary. They don't need them for protection. I know what's in the FAR. I know how to negotiate and move those clauses out or modify those clauses. So again, that's where that, empathy and understanding, it's a good thing to have, not just to be a decent person, but from a business sense standpoint, it will allow you to understand where you might have wiggle room and where you can push and where you can't. Next slide. So on that theme, understanding each other, the prime understanding the sub and the sub understanding the prime is really key. And you need to understand what the other party is most worried about. In federal government contracting, the prime is most likely worried about the idea of getting stuck in the middle. I can't afford to be stuck in the middle where I've got a claim or an issue or some fight or dispute going upstream against the government, but at the same time, I'm fighting my sub on an issue, whether it's the same issue or whether it's a different issue. I can't be in a position where I've got two battles going on at once, or my relationship with my sub deteriorating is making my relationship with the government deteriorate, or vice versa. And similarly, I can't have my subcontractor put me in a position that endangers my contract or relationship with the federal government, with the user, with the owner, etc. Meanwhile, the sub might be thinking, hey, I'm a smaller business. I'm less familiar with the FAR. This is a complicated space to be doing work in, and I haven't done a ton of work in this space. I need to protect myself if something goes wrong, and I need access to remedies. And we're going to talk about that in a little bit. Next slide, please. So what does this all mean? It means, all right, then you got to think about what goes into your contract. So as a prime, and we're going to be talking about this mostly from the prime's point of view because most of the time they have the negotiating power. And that's, again, because they only have so much wiggle room vis-a-vis the federal government and the regulations and what's going to be in their contract. So understanding where the prime is coming from is oftentimes what the subcontractor needs to do too. So we're going to be looking at this primarily through the lens of a prime contractor, but not just to help prime contractors, because looking through it through that lens helps both parties. And to the extent that there are certain subcontractor concerns that come up, we're going to address those specifically as well. All right, so if you're the prime and you're worrying about, what needs to go in my contract, flow down clauses. What do you want to flow down? Well, the mandatory clauses are a no-brainer, right? If the government's telling you, hey, I have this in your contract and you are required by law to flow it down to your subcontractors, that's, a directive you're going to want to follow. So if it's a mandatory flow down clause, you're going to want to do that. How can you tell which clauses are mandatory? Usually the FAR tells you. It says that you have to flow this down. Don't confuse mandatory and automatic. I have several clients that I've encountered during the years that think that they are the same thing. In other words, the FAR imposes an affirmative obligation on you to cut and paste that language into your subcontract. That does not mean it's automatically there. Quite the opposite. If you fail to do it because you assume it's quote unquote automatically there, you have failed to comply with the FAR regulation that tells you to flow it down. So make sure that you understand that mandatory means you take affirmative steps to flow a mandatory flow down clause down. In terms of what form of the clause must be flowed down, if you've got an updated FAR clause, in other words, for those of you who pay attention to this stuff, you might know that the FAR Council, revises clauses often. This might seem counterintuitive, but you actually want to flow down whatever version is in your contract, even if the clause has since been updated. The reason for that is that the whole idea of this is that you're going to flow stuff down so that the subs obligations to the prime mirror the prime's obligations to the government. So whatever's in the prime contract, that's the version you want to flow down to the subcontract. Next slide, please. So obviously the mandatory flow down clauses are a no-brainer, but what else do you want to flow down? And the idea, answering this question really begins with an understanding of why you're doing this in the first place. Why are you flowing down or including clauses in your subcontract? The idea is to protect yourself as a prime contractor. You're ultimately responsible for the completion of the contract and the project. You are ultimately responsible for the performance of your subcontractor. So, you don't want to get into a situation where you're finger pointing or blaming your sub. The federal government doesn't like that. They're not messing around. They want the work done, period. If it's late or if it's deficient, it's going to be on you. So you're trying to hold your subcontractor to the same standards that the government's going to hold you to. You don't want them to force a default, cause a notice failure, cause a delay, etc. Prime needs to be vigilant. So the idea is that you're passing things down or flowing things down to protect yourself because of your obligations to the government. And again, that's not different than any other context. That happens in the federal government world and in other worlds. But because of the stringent requirements that you're held to in the federal government world, this is a little bit more important or can be a little bit more nitpicky. Next slide, please. So you should be thinking about what clauses you need to protect against subcontractor default, what clauses you need to protect against notice failures, clauses versus administration, and clauses versus disputes, which we're going to talk about in more detail a little bit later in the presentation. So be thoughtful. You want to think about, how to flow it down. Do you want to flow down the exact language in a cut and paste way? Do you want to flow it down just in essence or purpose? Or do you want to not necessarily cut and paste and tweak the language, but just address an issue? Obviously, if it's a mandatory flow down clause, you have a little less freedom. But if it's another idea that you're just trying to do some risk shifting or risk sharing, that's when, you want to think, what really makes the most sense for this contract. And that might be one of those areas where subcontractors have some wiggle room to negotiate as well. If you've got questions about this, it's best to contact a legal professional, specifically one that's used to dealing with subcontracts in the federal government space. Next slide, please. So I want to show you an example so you can understand what I mean in terms of the government or in terms of the prime contractor needing to account for risk and take things into account and make appropriate changes or make appropriate clauses in their contract. This is an example where a prime got stuck. Terminations for convenience clause here on the slide is in every government contract, or I should say the vast, vast majority of government contracts. Contracting officer by written notice may terminate this contract in whole or in part when it's in the government's interest. This isn't a black mark against the contractor. It's not a default. It's just, hey, the government decided they don't need to go forward with this project and there's no point in wasting the taxpayers' money. It happens. Like I said, this is in almost every government contract, prime contract. So in this case, we had a prime contractor that was terminated for convenience. However, the prime contractor had not put anything in the subcontract, whether flowed down and tweaked or even addressing the issue. They had not put anything in the subcontract that addressed termination for convenience. They had the ability to terminate their subcontractor if the subcontractor defaulted, but they were doing a great job and the sub was doing a great job. Nobody's fault. The government just terminated for convenience. So the prime contractor was left terminated for convenience, no money coming in from the federal government, and they didn't have the right to terminate their subcontractor. So subcontractor said, well, terminating this contract where I was supposed to get $2 million, that's a breach of contract. You still need to pay me. And they ended up having to fight that out in court. It's not a good place to be as a prime. You want to make sure that, whatever the government can do to you, you have the ability to kind of flow that down to your sub. Next slide, please. So takeaway lessons from this type of problem for primes. You always want to avoid battling on two fronts or being stuck in the middle or having something that the government does or can take or can require from you that you don't have mirror obligations with your sub. So carefully study your prime contract, know all the possible scenarios, know what the government can do, know what they can't do. You can find that your rights and obligations under the prime contract are dramatically different from the rights and obligations of subcontractors under standard subcontract boilerplate clauses. This can be especially true in construction. So be careful. Don't think that just because you went online and found, some template subcontract that's covering you on a federal government contract. It most likely is not. You're much better having a template subcontract drawn up by an attorney that does this type of work that you then can modify contract to contract. You need to protect yourself. If you have an obligation to the government that kind of brings the sub in or relies upon or implicates the sub, slow it down or at least account for it or have a risk shifting or risk sharing provision. If the sub could impact your ability to fulfill responsibility or perform, you want to make sure that the subcontract addresses that. Make sure that the subcontractor is accountable to you at least to the same extent you are obligated or responsible to the government. You want to make sure, again, your rights vis-a-vis the sub mirror the government's rights to you or from you. Next slide, please. So primary objectives of primes, make sure that the obligations of the sub to the prime mirror the obligations of the prime to the government. Make sure the subcontractor is bound by the same procedures as the prime contractor. Next slide. So now let's shift a little bit into, from a subcontractor's point of view, the biggest subcontractor mistake that we see is agreeing to a non-specific catch-all type flow-down clause. So something like the subcontractor shall assume to the contractor all the obligations and responsibility that the contractor has assumed to the owner, or the subcontractor shall assume to the contractor all obligations set forth in the prime contract. Or our final example, all relevant and applicable provisions of the prime contract are incorporated by reference, except that owner shall be changed to contractor and contractor shall be changed to subcontractor. So next slide, please. What's wrong with this? This seems pretty consistent with what we've been talking about in terms of the advice given to primes, right? The idea of mirroring obligations. Wrong. The idea that we're talking about is taking individual clauses and including those clauses in your contract. Here, you're lumping everything together. Here, there's no kind of spelling out of the individual responsibilities. In order to protect you and in order for subcontractors to protect themselves, subcontractors need to understand specific obligations and responsibilities, scope of work, compliance requirements. Otherwise, you're risking default, notice failures, all the things that the whole point of this presentation and the flow down clauses and everything you're hoping to avoid. So vague catch-all clauses don't put subs on notice of their obligations. If you've got a 3-sentence thing just saying, we're flowing down everything in the prime contract, especially an inexperienced sub or a sub who's very experienced but doesn't do federal work, isn't going to know about differing site conditions, isn't going to know about when they need to give notice about a change, isn't going to know about delay provisions, isn't going to know how to fulfill the obligations that they have to fulfill in order to make sure you as a prime are covered or make sure that they can cover themselves. Next slide, please. So real quickly, going to go over an example of what I am talking about. In this case, a sub didn't know the rules because they agreed to a vague catch-all flow-down clause. Inexperienced sub had no idea about FAR notice requirements. As a result, and this was an asbestos abatement case where there was a differing site condition, the differing site condition has certain requirements that if the prime contractor wants to have a request for equitable adjustment, which would allow them to increase the contract price, allow them to then mod out the subcontract to pay for the unforeseen and more expensive conditions that are encountered on site. That's all great, but it requires that there is notice given before the conditions are disturbed. Subcontractor had no idea about that because they had a vague catch-all flow-down clause. They didn't have a differing site conditions clause that spelled out their obligations. So subcontractor didn't give proper notice to the prime, which meant prime didn't know. They didn't give proper notice to the government. So both the subcontractor's ability and the prime's ability to recover were impacted. They both had to fight like tooth and nail, and it made it a lot harder and made it not get all the damages that they could have gotten because the sub didn't know what they were doing. Poor drafting, therefore, hurts both the prime and the sub. If the sub doesn't understand their obligations, it's not just going to hurt the sub, it's going to hurt everyone. Next slide. So takeaway lessons for subs. Make sure you understand obligations and responsibilities in specific terms. Do not sign vague flow-down catch-all agreements. If there's a reference to the prime contract documents in your subcontract, get them. If you can't get them because there's a classified issue or whatnot, say, I'm not signing a subcontract that references documents I can't review. If you want to account for things in the subcontract, you need to spell them out. You want to know what you're agreeing to. It sounds like a pretty simple concept, but a lot of subcontractors don't do it. Bonus lesson for primes on this note, like I said, if the subs don't understand their obligations, it's not just going to blow back on them, it's going to blow back on you. So make sure that you are carefully drafting your subcontract. Next slide. Subcontractors' primary objectives, kind of summing up this area. Subcontractors need to know what their obligations are in specific terms. They need to know what contractual procedures they have to comply with, notice, disputes, etc. Subcontractors want to avoid assuming liability for compliance with clauses that are not mandatory or are not applicable to their subcontract work. Next slide. So the last thing we're going to talk about before we wrap up is what is called a pass-through claim. Subcontractors cannot go straight after the government when there is an issue attributable to the government on a job. They do not have what's called privity of contract with the government, and because of that, they do not have any exception to the sovereign immunity rule, which basically says you can't sue the federal government. Only people who have contracts with the federal government can sue the federal government under the Tucker Act and CDA, Contract Disputes Act jurisdiction. Subs don't have that. So a sub has to rely on its prime to do what's called sponsoring or passing through its claims. Those claims are ruled by the Contract Disputes Act, which is another complicated set of laws. It requires exhaustion of administrative remedies. It can be a long and complicated legal process. And through that process, the prime litigates the claim and the sub supports it. Next slide, please. Unsurprisingly, this can be a huge source of prime and sub conflict. So it's one of the most important things to account for and negotiate and draft carefully in your subcontract. Why is this a huge source of conflict? Because the prime and the sub are coming at it from very different standpoints and they both have valid concerns. Prime is going to be scared of that two-front battle, being stuck in the middle. And another thing that they're going to be really scared of is certification issues. When you submit a claim over $100,000, you have to certify that claim. And if you're doing as a prime what's the passing through of a claim for your sub and you certify it and it turns out that your sub was messing around and there's something fraudulent in there, you are on the hook. So primes can get very, very scared of certification issues and of forfeit, fraud, false claims act, etc. Meanwhile, subcontractors like, well, that's all great and I understand that you need to protect yourself, but hey guy, I need some remedies. I can't go after the government myself. I don't want to sue you for an issue that's the government's fault. So I need some sort of recourse or some way to recover the damages I have if the government did this. You need to agree to pass through my claims. Next slide, please. So the key is draft your subcontract to address these concerns. You want a disputes clause that outlines cooperative requirements, addresses concerns. For example, if the sub does X, that's going to assuage the prime's fears, and that's going to require the prime to sponsor. Sub will help in preparation, litigation, etc. Maybe you want to address litigation fees and who's going to be paying them. You're going to address those FCA fraud certification issues. You're going to want a disputes clause that differentiates between disputes between the sub and the prime and between the sub and the owner. In other words, if the sub and the prime are pointing fingers at each other, that's a little bit different than if both of them are pointing the finger against the owner. Disputes clause is you want the disputes clause to explicitly reference the Contract Disputes Act, the CDA, specifically reference the process that the CDA requires so that the subcontractor is aware that that is what they need to abide by. You're going to want to mention what happens with arbitration and the Miller Act. Next slide. When you see a lot of the prime disputes happen, the prime sub disputes happen, it's because the prime either refused to honor a pass-through claim, refused to sponsor it, refused to pass it through, or they didn't do it quick enough. In the first case, they might be right because it's an illegitimate claim, or because the sub didn't do what they were supposed to do to assuage the prime's concerns, the prime's fears, or the prime's trepidation in terms of falsification or certification issues. Sometimes, though, they're just being a jerk, and the sub is right to sue them. When this happens, it's usually brought in the appropriate U.S. district court or sometimes in a local state court, depending on what the contract says and if there's diversity between the parties. It might proceed to arbitration. Most likely, if the prime contractor drafted their subcontract really well, they're going to be able to stay that claim and try to deal with it vis-a-vis the government and go back to that CDA process. And that's why understanding that process is so important to negotiating the contract. Be aware that if you're dealing with construction, there's also some different circumstances where the subcontractor might go after the prime's surety if they're not getting paid. That's a Miller Act claim, and those are brought in district court and can sometimes make these subprime things a little bit more complicated from the prime's point of view. They're a good tool to put pressure on from the subcontractor's point of view. So again, careful drafting is going to require you to address these issues and whether those kinds of claims can be stayed if, the prime has something going on against the government. Generally, sub versus prime disputes are a creature of state law, but, and again, that's going to depend on what state you said governs the law on your subcontract, and you're going to want to be careful about that because states handle things differently. So consult an attorney. But again, remember talking about the fact that you've got this interrelation between all of the parties and the owner is involved. So that's going to mean that the CDA and the FAR and agency supplemental regulations always kind of come to bear on what's going on between these sub and prime disputes, and you really need to take that into account when drafting your subcontract. So next slide. Finally, critical considerations to take into account when you're putting your subcontract together, those mandatory clauses that we talked about, protecting yourself with notice provisions, making sure the sub knows what notice they need to give, making sure that you don't get stuck as a prime where there was a termination or a default that the government is holding you responsible for and you can't pass that through to your sub. Delays and LDs, same thing. Don't want to have a situation where you're on the hook to LDs for the government and you haven't had an LDs provision in your subcontract. Suspensions, changes, making sure that if there's a negotiation or a dispute about changes, that the sub is required to continue to prosecute the work. Dispute resolution, that's what we just talked about. Costs and pricing, term and termination, and then of course labor and employment issues, ethics requirements, other compliance concerns. Sometimes you need to flow those down as well. And finally, IP issues that can come up, in certain kinds of contracts. So next slide, please. With that, we are all done for today, and you can reach out to me at the email or phone number that are on the slide. You can also look for me on LinkedIn, where I will post that I'm doing other presentations such as this one, and I post from our government contracting blog, etc. As always, thanks for being a wonderful host, Jennifer Schaus and Associates. Thanks for everyone out there for joining us today.
Thank you, Maria, for a great presentation and sharing your time with us. And thanks to everyone who joined us. The recording will be on our website and YouTube channel within the next 24 hours. Please join us this Friday as we cover each part of the FAR, and join us next Wednesday for more hot topics in federal contracting.